guys, it's Kathy. I hope you're doing well. Kelly, I hope you're doing weller. Wellest. More wellest. I hope Kelly is doing more wellest right now. She's probably a bit nervous, but she's been through this before. She knows the drill. And you know Kelly, she's a champ. So she'll be fine. And we'll hear from her very soon, I hope. Right? Right? Any minute now? Maybe during our stream? No, we won't. Weller-er. More weller-er. Most weller-er. So, sit back and relax today. We don't have a crazy, nothing crazy happens today. It's interesting. We have, this is how lawyers throw down. This guy goes on a full frontal attack in the lawyer type way. So we're going to see that. We're going to start with our other bow tie judge, Judge Johnson. And I don't know if you remember, in his court, not just his court, in Colorado there, the prosecutor can put a cap on a plea. So the defense attorney and the prosecutor can come up with a plea deal, and they can say, but we're going to cap it at 8 years. So what they're saying to the judge is, you can't sentence him for more than 8 years if you go with this plea. Everywhere else in the world, well, I don't know about the whole world, but everywhere else, the judge decides the sentence. They have a plea deal, they give him the recommendation, or her, and she decides the sentence. But in Colorado, in this part, they have these plea deals with these caps. No cap. So the other judges, I think, are fine with it. And if you remember, I showed Judge Johnson before, and he just hates these caps, and he hates when an attorney puts a cap in front of him. So we're going to start with him, and I have the whole thing. Like, normally I cut out his pauses because he pauses to think a lot, but not today. Today we're technical. Today we're going to watch the court case as it is, and enjoy court as it is, instead of just being entertained. Oh, I'm missing one. But first, here's a quick clip from the same judge. Just a quick one. A full frontal quickie, even.
If you want him gone, I'll excuse him.
I would feel more comfortable with Mr. Kuhn off this jury, Your Honor.
Me too.
Okay. All right, then we'll let Mr. Kuhn go. And I think that is everyone, right?
Your Honor, the only other person I noted was juror number 27, Mr. Escobar, who
He's gonna stay there.
Okay.
I'm not letting Mr. Escobar go.
I
I start this with work is not it, and there's always somebody, usually a doctor, who thinks that they're more important than everyone else. He can sit during voir dire. You can inquire if he actually makes it up here, which he will. And we can go from there, but I'm not just going to cut him loose because he says he's busy.
Thank you.
Go judge. Okay, now let's hear him talk about how much he loves these caps.
Drug felony 2.
Just so you know, he sort of gets his way, but it's the worst possible way to get his way in this one.
In case 24 CR 5152, that 24 CR 6004 and 24 CR 5665 would be dismissed.
Correct, Your Honor.
Looks like there's a waiver of the 2 prior felony rule, but otherwise sentencing on the DF2 is open to the court, and that is an aggravated sentencing range of 4 to 16.
Oh, that was my bad. That was jury selection. So remember yesterday in the stream I said jury selection is never, never interesting. It's horrible. That was his jury selection. And I said yesterday in the stream, well, maybe, because I knew this happened. So I knew I had to play it today. Yeah, that juror was trying to go home because he was very important. And the judge is like, nah, he's not going home. Oh, yeah, it's on the tip of my tongue. Demi, Demi, I can't remember her name. Nellie, Demi, I don't remember her name. Yes, I remember. I have a whole bunch of clips of that. I just don't have the verdict, so I never played any of them. I have, I bet I have 40 hours, between 20 and 40 hours of that trial. Oh my gosh. All right, now we have an answer. Now I can play it. Just kidding, guys. It's 40 to 80 hour trial. And I don't have every single clip in order, but I have enough. So what I might do is put that on my Patreon. You remember the goat lawyer, Chrysanthou? She's in here. And it's a little political, but it's Australian politics, so we're fine. It's a really good case. It's a really, really good case. So, yeah, I'll put that on my Patreon, and you can enjoy it there. It's hard because I have it on like 3 or 4 different computers, and I have to piece it together in order. But I do not have every single day. I mean, I tried to record it every single day, but for me to record a trial that lasted what did that last? 4 weeks long? I couldn't get to it every single day. I couldn't. I was doing my streams. So, all right. Now, if you remember, this guy, if he pleads to count one, a whole bunch of other cases here are going to be dismissed. A whole bunch of other cases are going to be dismissed if he pleads to count one. All right, all right.
Years. Is that your understanding of what you're doing?
And Your Honor, just to
I
clarify,
guess it's enhanced technically.
because I don't believe you put it on the record, there is a stipulation to a cap of 8. I understand the court's reticence to accept caps like this.
I don't see a cap in here. Oh, there it is. Yep, you're gonna have to justify that to me.
And Your Honor, so I would be requesting a PSI should the court entertain this plea agreement. I think that the information contained in the PSI would add to and would be part of the justification. So I'm wondering if the court is willing to consider the plea as accepting it today with a record made that it may be withdrawn should you not be in agreement with the cap and the agreement reached by the parties.
And Your Honor, I would add that in this case, a cap
I really
was
hate doing that because it's just a colossal waste of time. You know, every other jurisdiction has made clear that sentencing's up to the court. This is the only place that does this, and it really makes no sense. Statute and Constitution empower us with sentencing. So why should I accept the cap?
Your Honor, and I'm happy to start. Mr. Sands, there's a lot that goes into these cases that I do believe is mitigating, but to start with kind of.
Unfortunately, for all of us here watching, this lawyer is about to say a whole bunch of words that mean absolutely nothing at all.
What Mr. Sands has been doing since he's been in custody. He's been in custody for quite some time on these cases. He has connected with a multitude of programs, but ultimately was made in contact with the Mary Putnam, with the Reciprocity Collective, which connects individuals to other services and facilitates kind of transport and everything else with getting them to inpatient treatment. Through Mary Putnam and the Reciprocity Collective, he connected with Roads to Recovery, ultimately was accepted into Roads to Recovery, and was established a place there, even though they were closing out the program and not accepting new individuals into it. All of this was set up if we could get to some sort of reduced bond so that he could show his initiative in addressing any sort of underlying problems, going into inpatient treatment, receiving treatment, and being as successful as he possibly can. Additionally to this, it looks like the two cases that are going to be
I don't know about all those exclamation points. I don't know if you understand the direction. Micah, maybe we should have a talk.
dismissed in review of discovery are significantly mitigated as to the allegations contained and the support they have for what was recovered and or whether or not it meets the legal requirement for an amount in possession or a transaction to have occurred. I do believe that these were more questionable as to whether or not they were trial cases, but from discovery, it looks like these were not as alleged to have the same sort of support that you would see. I do believe that Mr. Sands has somewhat limited criminal history. The court can see that there's a significant charge out of Florida that he was incarcerated for a long period of his life.
I
But
can
since then,
imagine it's actually an F1.
Judge, be quiet. Hi, Fozzie.
What is that case?
I'm sorry, Your Honor. That's a manslaughter case out of Florida.
Yeah, it says F1, which I can't imagine that's accurate.
Right.
What level felony is it?
See that?
I
Micah?
believe it was, let me just double check. Do you remember what the level of felony was out of Florida for the manslaughter? But it kind of,
Sorry, go ahead.
and additionally, the facts as alleged in all of these cases don't contain any instances of violence. There's not guns associated here. There's not threats or anything like that. As alleged, these are simply drug cases that don't have vast amount of quantities that's outside that is reasonable for personal use. Essentially, without at this point in procedure admitting to any of the allegations, what was found and what was recovered kind of tells a story of somebody who was in a position of transaction for personal use and an addiction. Not that there was a huge menace or somebody producing a vast quantity that is part of a large scale operation or anything in consideration of anything like that.
I'm not real sure I'm impressed with the dealing to support personal use argument. You're still dealing. That's still people getting fentanyl and dying. So I'm not overly impressed with that. Dealing is dealing.
If I may jump in, Your Honor, in this case, among some of the factors Mr. Britton has already mentioned, the cap of 8 reflects the top range for a presumptive DF2. I don't know procedurally why things unfolded the way they did in these cases, but Mr.
And you're
Simmons
putting in a built-in discount for volume of crime because I don't accept them.
we are putting in a discount for the reality that this case 24 CR
Nice.
293, the only reason we're in the enhanced range in the first place, pled while Mr. Sands was on bond in this other case that was open in front of the same court. We're acknowledging that's an unusual process and getting ahead of any potential problems that might cause down the road. Also, given the fact that the other two cases, the later ones, are very minimal amounts, we are considering that mitigating in this offer. This was not the original offer conveyed. It has gone up since the first offer was made in 24 CR 5152, but that is why there is a cap presented in this case, Your Honor.
So he realizes he has to give this. He has to accept this plea with a cap on it. He does not want to, but he has to. He's not trying to find a way out of it, but he does not like this. It was always Fozzie, you know that. I told y'all it was going to get shut down. I said it over and over again. My fingers bled. Bled. Charlotte, we missed you the last couple days. Some mod was pretending, but no one can pretend to be you. Bonjour, Charlotte. Sakura Blue. I think I know more. Wee wee. Au revoir. I know that one too.
Do you have any idea what the facts are of that manslaughter case? Is that drug related?
Not that I'm aware of, Your Honor.
These judges are bipolar.
Your Honor,
Yes.
and I apologize. It's my understanding Mr. Sands now wishes to withdraw this plea set for trial.
So there we go. The guy said, nah. The guy said, nah, forget it. I don't want to do this plea anymore. After all this to get the plea. Hey, Mom Spaghetti. I hope you're doing good. Are you getting
Is
ready
that what
for
you want to do,
Christmas?
sir? Because
Judge, are you getting ready for Christmas?
right now, if I accept this, you've got a cap. If you go to trial, there's no caps. So it's up to you. But I mean, this is, you always hear attorneys argue they took responsibility for their actions. This is a taking responsibility. You go to trial, you're not getting a taking responsibility bonus.
Yes, sir. I agree for withdrawing the plea.
Say again?
I agree with withdrawing the plea.
Oh, well, there's no plea to withdraw. All right.
I have not started yet on anything.
All right. Well, I do note that in 24 CR 5665, there are no motions filed, so we can vacate.
So now that he said that, now what the judge is about to do, guys, he had all these charges. Case. He was only pleading to the first one. He wants to go to trial. So now the judge is setting up for trial. And he is busy. This judge is busy. His docket is stacked. But he loves trials. So it's all good. Here we go.
12-6.
Hi, Broken.
And 24 CR 5152, no motions filed. We can vacate 12-6 and also set trial.
Smurf is a
And 24 CR 6004 will enter a not guilty plea. Motions are due December 30th.
Smurf is it plugged in?
We'll do a hearing on motions in that case on March 28th at 2 o'clock.
Thor's here. Hey. We got everybody here that hasn't been here for a while. I love that. I just do. But we're all missing Kelly so badly this morning.
Speedy trial on 6004 is June 3rd.
Kelly's in surgery today.
All right, so it looks like Judge Bland took not guilty pleas in 5152 and 5665. So speedy trial is April 28th. In those two cases, we'll do the DF2 first. How about March 25th?
No, we don't. We say Paschetti. I want Paschetti for dinner.
Yeah, we're setting 5152 first.
Defense can accept that date.
Your Honor, I'm setting another trial in this courtroom, starting on the 24th, but that's the only conflict.
On the 24th?
March 24th. Am I looking at the wrong date?
We normally start on Tuesdays.
I may have written it down wrong, but I see 23 CR 6746.
You're trying to schedule all these trials now. He didn't want a cap, so he got what he wanted.
23 CR 6746, Finch.
6736.
Listen, I love food. A lot, most of it. There's not too many things that I will say, ugh, no, I'm not eating that. But I will definitely not eat a spag bowl. No. If someone said, do you want a spag bowl? Absolutely not. I will not eat that.
Yeah, it starts 25th.
What is that, though?
All right, we'll look for a couple other dates, but we may have to, that's going to be the best date for the court. You're also set the next week.
Okay, that's bomb. It's so good. I had it before. It's so good.
But April, well, wait a second. April 8th.
That works for the people.
And that works for me.
All right, April 8th, 2025. Is 2 days?
That sounds about right, Your Honor.
Everyone needs to be ready for a Monday start.
Hi, Nan. No, absolutely not. We call them mountain pies. If you do it over the fire,
Pretrial conference,
mountain pies.
March 24th.
You mean you can't eat them all?
Pretrial conference is the last date I will accept any plea that does not include count 1.
So, the pretrial conference is the last day he will take a plea that does not include count 1. They can still put a cap on if they want to, if they do this plea. But if they don't include count 1, all of these are going to trial. Every single one of these cases are all going to trial in all these days. And I'm there for it. I could get every single one of his trials. I'm going to try. I have a feeling he'll plea. His lawyer will talk to him.
We'll set 24 CR 293 to trail that DF2. We'll set it for 324 as well as 48 for status.
Thank you, Maiko. I try to mute when I sing. I just forgot yesterday.
The other one we've got to get in fast.
Fast. This is what they consider fast. You ready?
This is 65665. Let's do April 22nd on that one for trial.
That's a fast trial.
That works for defense.
April 22nd.
That works for the people.
How many days you want for that one?
All of these can be 2 days, Your Honor.
He has deep thoughts with himself. about every single case.
Want to do a pretrial at the same time as the other one, or
That works.
pretrial April 7th?
Either option works for the people.
Same.
All right, we'll do pretrial 3/24.
Hi, Clarice on replay crew. Hi.
Again, be ready for a Monday start just in case.
Kelly will be back. Kelly's okay. Ah, I don't like streaming without Kelly. I hate it.
All right, then that leaves 246004.
It's right. He has like 7 more words to say, so it's 3 more minutes long.
About May 13th.
That works for the people.
That works for defense.
No, in honor of Kelly, we should be drinking. She's getting some good drugs though today. All we have is beer. She's
We
going
do
in
pretrial on that one, April 28th.
Judge, she's going in for surgery.
Yeah, sure.
No, I wanted to play this for many days now, but I didn't think. No, not this one. This one was from today. The next one. The next one is iffy. It's an iffy one for me to play.
All right,
But it's
be ready
really
for a
good.
Monday start.
Judge Johnson is never a filler. He is the star of the show. He's out of custody. So with all these trials, he might not get all through them this in 2025. All those trials.
All right, excellent. Anything else from the prosecution?
Nothing from the people.
All right. Like I said, pretrial conference is the last day I'll take any plea that does not include count one. Otherwise, we will go to trial. We're ready, and we'll see everybody at those pretrial dates, except for the one case, which I guess we have an earlier setting for motions on March 28th. So that's the next time I'll see is March 28th.
Your Honor, and understanding that decisions get made quickly when faced in these decisions, if further discussion proves fruitful to submit a plea to the court, would the court be willing to add on via motion, or would we go?
Yeah, you can have it on any time.
Okay. Would the court prefer that to setting an intervening date right now?
It's up to y'all.
Okay. I'll file a motion should we come to an agreement.
All right. I was good.
His dockets are 8-9 hours long every day. He gets through 80 of these a day. I mean, he gets through a lot a day. He does. So there's a few judges, like we see Judge Fleischer, and he goes from like 8 to 1. there's a few judges that I have that they just go all day long, over and over and over again. Their caseload is so full, and he's one of them. I could fill 3 streams with just him every day, easy. Okay, we're gonna do one more little clip before we go into the shenanigans, and I mean shenanigans. This is a child support.
Number 6.
Hello.
Good afternoon. So you brought the troops with you?
Our 18-year-old son wanted to come and
Your
my
protection detail?
friend came.
Well, we got this guy. Yeah, maybe not.
Yes, and
Okay.
if you hear my son yelling, he's gonna die, he's gonna die, he's gonna die, he's playing Risk, so he's not really gonna die. He's not playing Overwatch today. I think I could be wrong. I think he's playing Risk, which is very, high volume.
Oh. You're the big file of the afternoon.
Yeah,
No, this is nothing. We had one this morning. There was 3 files.
a lot. Yeah, not fun.
No.
I walked in. I was taken into a police station once, and they had 3 thick files of me on their desk. And I was sweating. It was horrible. I was at work at the university where I used to write code and stuff. And the cops came and they made me come into the office, come down to the station. They put me in the interrogation room, and it was like 3 files, like this thick, all on me. And I was like, and I knew I was in big trouble, guys. I knew I was in big trouble. It wasn't me. It was really my sister. My sister had always uses my name. She's a criminal when she does stuff. She just got a DUI. I don't know. I'm gonna say 6 months ago because time. I just don't know. And she gave him my name, DUI. She gave him my name. But when I saw that they had these 3 thick files on me, I can't even tell you how terrifying that was. I thought, oh gosh, oh man, I'm going to jail. I'm going to jail. There's nothing, and I was going to jail. I'm telling you, they were not listening to me. I was saying this was my sister. This was not me. And he said, well, whose name is that? My sister wrote my name down. Whose name is that right there? I said, yeah, she wrote that. She wrote your name. Why would your sister write your name and to get you in trouble? But she did. And I was allowed to look at it. He was showing me this stuff. I was allowed to look at it. And I saw a picture where she had bangs, and I never had bangs before. And I'm like, look at the bangs. I don't have bangs. Do you think I just grew my hair out? There's bangs. That's my sister. He didn't care about anything I was saying. He did not care that it wasn't me. He wanted me in cuffs. He wanted me locked up. And I'm begging my case, and it didn't matter to him at all. But once the bangs came out, he's like, where is your sister? I'm like, I don't know. You go find her. I don't know where she is. And then he's like, well, if she ever uses your name again, you let me know, and she's going to get in trouble. So she does. She still uses my name, and I let them know, and she does not, in fact, ever get in trouble. But anyway, I'm sorry. There's 3 folders gave me PTSD.
Mr. Ayala on the phone. Press *6. Otherwise, we won't be able to hear you. I think there we go. Say hello.
How you doing?
Good. So this is the father's request for modification.
Yes.
Let me see what DCSS has for us.
We're showing he's currently on unemployment, $450 per week.
Okay. Is that right, sir?
Unemployed, yes.
Okay, and you're not married, right?
No.
And you don't have any other children that you support?
No.
And you have these 3 children, only 2 of which are underage now. So Alejandro is graduated from high school,
Yes, he's graduated from high school.
okay, and he turned 18 in January.
That's correct.
Sir, do you have any parenting time with Isaac and Selena?
No, because they don't want to come with me.
Okay. And ma'am, it says you're working, you make $4,009 a month before taxes?
How much does it say?
4,009? Ms. Foster? where'd
Oh,
get the number?
probably, yeah, because I get like 3,900 after.
You get 39.84 is your
Yeah,
salary, and then there's like a $25 per
Yes.
month bump. So
Yes.
that's how we got there. Yeah.
okay,
And you own your home?
yes.
And you have health insurance premiums and retirement, so you work for the government too.
I work for the state.
Just no union dues.
Now there is, I started paying that, I believe last month. It's about $80 a month.
Do you have any 401k, 457, 403b?
With the state?
Yeah.
Or not with?
Those
the
are
state, like-
voluntary.
Oh, okay, not with the state, no.
Okay.
I had a 401k with my previous job, but
But you're not contributing to
that,
it.
no.
That's what I'm looking for.
Okay.
Contributions. Okay.
Tonys. Where's the last of your Tonys? How comes it just says Tony? I love your comments. I'm so glad you're here. I can't believe how many people from comments are coming into the stream. It's nice to see you. It's been a while.
And no childcare expenses.
No.
Are you still,
union?
are you supporting him too?
That is correct. Yes. Yeah.
Get him out there working.
Well, he started working for Wendy's, but then after the governor put the minimum wage to $20 an hour, they cut him to just 1 day a week, 4 hours a day, 4 hours for that week. So it's been a mess.
He must have been low man on the totem pole. Because they need people
Because he had,
all the time. I mean,
yeah, he had just started working there, so then
Yeah.
he got the short end, and he's been applying everywhere and hasn't gotten anything else. So I got stuck with the
I could
bus.
put him on a seat worker. We could just keep
Yes.
that going. Okay. So the guideline amount of support, which is a low income adjustment, is $508 a month. So it is a reduction.
Even though I have full custody.
Yep.
And then I had 2 questions for.
I have a quick question too. Ladies, I need you to think back. About what month? I'm trying to find the first the first time we met Will in Judge Fleischer's courtroom. I'm trying to figure out where that video is. Do we have any idea what month? Egypt. Wow, that's awesome. That's so cool. Anyway, we are, yeah, I know, I'm growing out my bangs and my hair back to where it normally always is. No more short hair for me. The first video of Will, that's what I'm looking for. I'm getting distracted. I'm looking for the first video of Will. So if you know what month maybe it might have been in, let me know.
One back in, I think it was like 2018 or 2019, he removed the kids from his medical insurance when he was working, and I didn't have medical insurance at that time, and he didn't want to pay any of the out-of-pocket expenses. I have text messages where he says he's not giving me SHIT. So this whole time I've paid all the out-of-pocket expenses, and he's paid nothing all these years. And through the court, it does say that he has to pay half of the out-of-pocket expenses.
Yeah, that's what I'm looking for right now.
This is California.
is what it says.
And I have a
I'm
text.
sorry, but
from him saying-
the judge said, I'm sorry, but the judge said no because my expenses through work was going to be almost $300 a month. That's
Well,
why they didn't.
You're talking about why you didn't have the insurance.
The judge told us
Yes.
both had to have the kids on our medical insurance, and he removed them anyways. And I have messages where I'm asking him to keep the kids on there because I didn't have medical coverage, and he still removed them. And I've had to pay a lot of money out of my pocket for root canals, for a lot of medical different, dental expenses because he removed them. But the judge had said that we both had to have insurance and that he had to pay half of the out-of-pocket expenses, and he has done none of them.
Your Honor.
No, the judge.
November, just a moment, sir. November 2nd, 2016, it's on page 2 or attachment 7. It says parties to split evenly all reasonable uncovered medical and reasonable extracurricular and reasonable daycare expenses. It's a very long sentence.
And reasonable daycare expenses. Yeah. Yep. So he does owe half. So
Yes.
have you sent him copies of the bills?
Yes, text messages, and I've sent in mail, and
Oh, wait.
I have
Copies of the bills.
of the
Text
bills as well.
messages
Yeah, no, emails. There's emails that I've sent him with
Or
the copies
it's
of the
attached.
bills.
Okay.
Yes.
Well, then what you need to do is what the lady that sat in that chair a little while ago did. File a motion. Identify what all those expenses are. Have copies of the invoices and a summary. Now, the summary should be a little bit better than hers. She says 1 through 23 and just has dollar amounts. Doesn't tell me what it's for.
Okay.
So you should tell me,
so
okay, $48 for 1/2 of.
so like the date, which child it's for, and
Right.
and with the medical. Okay, and the amount. Okay.
Yep. And then he'll need to be served with that, and we'll have a hearing, and I'll determine what, if anything, he owes in unreimbursed medical expenses.
Okay.
And then once I've done that, DCSS can enforce it.
Okay. Thank you.
Okay, so the support order starts November 1. So the previous order was $679. That was that same November 2nd order. And that was for 3 children, was it not?
It was before I was getting like $800 or $900, and then when Alejandro was graduated, then I started getting
The 679.
yeah.
We're
So the
enforcing 809 for 2 children. Is that what you said? I thought I heard 6 something.
She said it was 809 for 3
Well,
children.
no, it was nine. No, I was getting
It
900.
was
I hit somewhere
Oh, okay.
3.
It was 1,004 when it was 3 children.
Oh,
and now it's
1,004. Okay.
809 for the 2.
Oh, now it's 809?
Correct.
I'm just looking at what I'm told.
So, got it.
809, what's the date of the order?
Oh, that I can give you. 9/17/20.
Okay, they were going back to 2016.
Yes.
That's the only order.
The mother does not have to pay child support. The father does. But there was a divorce. Did we get to the 401k yet? I was distracted. There was a divorce, and he got part of her 401k through the divorce, $13,000. Unless we haven't got there yet. I was distracted.
That they found. Okay, was that in a family support file?
No, it's in the 14FL.
Okay, yeah, it's the only file that I see we have. Okay,
So
Well, so that's it,
how much
508.
is 508? And then once he gets a job, because he's not going to tell me if he started working. So will you guys know, or child support services know?
when did you stop working, Mr. Ayala?
July.
Okay, and what have you been doing to look for work in the meantime?
That just hurts my feelings, guys. Sir, it is not July. Nobody says July. Around here, we call it July. It's July.
I've been applying everywhere.
And no offers?
There's no offers.
We are all losing our
What kind of
minds
work do you
here.
do?
Warehouse.
Well, I would think that would be hot right now with the holidays coming up.
Yeah, but there's no. I applied and no respond.
Well, so how are you being supported?
He's a liar.
The unemployment.
Yeah, but that's got to be way less than what you were making when you were working.
Well, yeah, but if there's no job, and then I have a credit card too.
And Your Honor, like, I know my credit cards are up the roof too, because I've been, like, any expenses, like for the kids and everything, I've been having to put it on the credit card.
That's because he's not working.
Yeah.
Your Honor,
And on top of that, you owe me $13,500. I have not seen anything.
For the 401k, I gave you the paperwork that you had to sign, and to this day, you still have not given it back to me so that I could bring it into court to get the quadro completed.
Well, I thought there
can't.
was something in the judgment that said a quadro wasn't needed.
When we got a divorce, we were told to do the quadro. So then I did everything and I gave him the paperwork for him to sign, and he took it and would not give it back to
And
me.
how much is in the 401k?
Well, no, because during the divorce, the settlement was for $13,500. I didn't have the money to pay him $13,500, so it's going to come out of the 401k.
Is
I
there
don't
enough
mind-
in the 401k to cover?
Yes, there's enough in there to cover it.
Okay.
So I just need the paperwork from him signed so that I can.
And I asked you
Bring it
plenty
in.
of times to do that, and you haven't. So how
You
do you
have-
expect me to pay the medical expenses if I haven't received the 401k?
Your Honor, he has the paperwork that I need signed. If he doesn't sign it, I'm going to
No,
have
I
to.
don't. I don't have any paperwork.
I turned it into him the last time we came to court.
No, you didn't.
When was that?
You just
That was back in, that was already what, 2021, 2022, I think it was 2022.
Oh, okay.
Yeah, I turned in the
Well, so,
documentation.
Do you
And
have a copy
I've
of it?
also emailed him.
Do you have a copy of it?
I have it at home. So I'd have to print it and then
Send it to him again?
send it to him again, yes.
I am willing to bring it back for a financial review, although it won't be here. It'll be down the hall.
For the child support or,
Yeah, we're opening a new full-time child support department,
okay,
and they're going to get all the cases that end in even numbers, and I'm keeping the odd numbers, and this is an 8. So this is going to be going down the hall if we're continuing it out into February, which is what I'm going to suggest. 2 months
Honor-
is what he's done to find work. Yeah.
I was going to suggest a formal seek work order. It sounds like it's been a while.
But since July, anyway.
Well, he stated that he's getting no response, but it sounds like he might need some help getting.
Well, I'm not gonna get a job that is a minimum wage.
Well, that would pay more than unemployment.
Yeah.
All right, so I'll put you on a formal seek work order. It requires that you submit a minimum of 10 applications a week. At least 2 of them need to be in person. You need to keep track either on some contact logs that DCSS will send you or on just a plain pad of paper with the name of the business where you submitted an application, the name of any person you talked to, contact information, phone number, email address, however you are communicating with them. You also need to register with the Sacramento Employment and Training Agency. You live in Sacramento?
Roseville.
Okay, Placer County
Yeah,
has similar careers.
I'm registered in Sacramento, and I'm applying, and I'm putting all the where I apply on applications, everything on that paper, on the unemployment paper.
Okay. I think this is probably requiring that you submit more applications than what you've been doing, though. 10 a week. And if not, then I'm not asking you to do any more than what you're already doing. You just need to show us.
And sir,
But
do you have a
that's what I'm doing.
Cal
I've been
jobs? Do you have a CalJobs account?
Yes, I do.
So 2 months, so into February. Can be a Wednesday afternoon in 1:34. Okay, February 19th. Sorry.
February 26th.
February 26th at 1 o'clock in the afternoon in Department 134. So they should be getting you the new meeting ID number. And if you come in person, it's just 2 doors down from here.
And Your Honor, we would request that we order.
Trash can. Your trash can outside, when it snows, you just move it. If it's still, and then the dog has a little square for the dog, and then you move it back if it's still snowing. Hey, Lacey.
To return with video or in person.
Done. So when you come back, you need to either have a device that has video or come down to the courthouse in person.
Okay.
All right, that's all for today.
Trash can
Thank
has
you.
wheels. Put the trash can, once it starts snowing, put the trash can in a little square right outside.
And that leaves us with.
Okay, it's time, guys. We are going to Connecticut. And we are going to, I can't even remember what the case is about. I don't think it really matters what the case is about. It's very technical. It's very lawyery. It's very nerdy. This is extra nerdy. But it's also very, they're just bare knuckling each other with words. And the older guy talks the most. And the younger guy just sits there flabbergasted, wanting desperately to talk so badly. But, okay, here we go.
Thank you so much.
Of course. Now, with that said, there is the motion. I have reviewed the relevant papers, and I would be prepared to go forward and at this point to make certain findings concerning valuation, debt, equity, fees, expenses, and the like, and to talk about a possible law day. Okay?
Could I be heard before we get to those issues, Your Honor? Because there are matters on the record that I feel need to be addressed.
Okay, before I make my findings?
Yes, Your Honor.
All right. Well, what would there be?
To start off, this is the second action. The first action was filed back in 2006. They are including in their expenses and debt calculations interest from the date of last payment in the spring of 2006 through to today. The first 2006 action.
This, remember, we're in Connecticut, so they have this mouse that randomly jumps on the screen. There's nothing I can do about it. It happens in a lot of Connecticut courts.
Was withdrawn by the plaintiff bank about 5 years later. I don't remember the exact date. But they withdrew it after they were under pressure from the foreclosure court at that time for not having complied with orders regarding pleadings and filings of papers and pleading issues and whatnot They didn't follow any of the pretrial orders, and the court was about to slam dunk the bank. Judge Tierney was not looking kindly on their shenanigans, and he was about to act, and the bank promptly withdrew the action to avoid that. They have a right to withdraw the action. They don't have a right to withdraw the action under those circumstances and claim interest from then until now on delay and confusion that they themselves sowed. And to follow up to that is, as ye reap, so as ye sow, so shall ye reap. And there's no answer in their pleadings or in their debt calculations for what they themselves caused, which is a dozen plus years of delay and confusion. That ties in to the pleading issue. We had a deed invalidation case prior to the foreclosure initiating, and the deeds vesting title in the mortgagors, purported mortgagors, were invalidated. We had those deeds invalidated. We spent a good deal of money and in my blood, sweat, and tears to get the jury verdict invalidating those deeds. And then the bank went forward as if that didn't happen. And in fact, the trial court back at that time did what trial courts do often in foreclosure matters. They conflate the rules that call for foreclosures to be expedited to grease the skids toward a foreclosure judgment. They conflate those procedural rules with substantive rules on the attention to detail that these large sums of money require. This case is a good example. We sat back and let the other brother plead the initial stages of this case, but then it got down to when a motion for summary judgment and pleadings were going to close, and we did our filings. The trial court at that time overruled our filings, disregarded them, and went to judgment. I took an appeal, and the appeal is in the record. It is Wells Fargo v. Triglia, 156 Con Ave, page 1. That foreclosure, this is the same foreclosure action, and in that appellate court case, decided in...
He goes too far, though. He does.
March 2015, the court reopened all the pleadings in this case. The appellate court ordered the opening of pleadings and that our answer special defenses and counterclaim be handled in the normal course. I can read the exact, the judge, here's the exact wording of the court. The judgment of strict foreclosure against Patrick Triglia is reversed and the case is remanded to set aside the default entered against him and for further proceedings consistent with this opinion. The opinion basically directed the trial court to hear the case, consider the answer, consider the special defenses, and consider the counterclaim. The banking industry shortly thereafter succeeded in hoodwinking the trial courts and appellate court in Connecticut with the initial Flowers decisions.
Attorney Brad, I'll hear you, but let's not, you know.
I got carried away. I withdraw that, Your Honor. I apologize.
Thanks.
Okay.
Burn.
Let's use the Supreme Court
That was a big bird.
language. That Blauer's doctrine was a doctrine of murky origins, which was a more delicate way to say the same thing that I shouldn't have used that language. So murky origins prevailed, and our counterclaim was disallowed because during the Blauer's case, we couldn't plead it. But the special defenses are extant. They were filed November 5th, 2012. They had initially been overruled by the trial court and subject to the order of the appellate court to reinstate the answer special defenses, pleadings, and counterclaim. The counterclaim went the way of all Blauer's decisions. The special defenses did not. The special defenses haven't been ruled on. The trial court's finding on liability didn't involve any analysis of the special defenses. The special defenses included that
This guy right here just needs to breathe. He needs to breathe.
special defenses. The special defenses included that the case of Patrick Treglia and Michael Treglia v. Robert Treglia, wherein the deeds, underlying deeds here were invalidated, was res judicata or collateral estoppel on the issue of the mortgage deed, because the same lawyer, Alan Lake, and his deposition is in evidence, he handled the deed from Robert to Edna of a 1/2 interest. He represented the bank, Optimum Mortgage, and option one, and then he did a quick claim deed immediately thereafter. Those deeds were invalid, not the mortgage deed, but the deeds were invalidated in the Patrick versus Michael litigation as pleaded in detail. So we have a deed filed at 9:56 a.m. on August 30th, which was Michael to Edna, Robert to Edna. We have a deed from Edna and Robert to the bank, which is the subject of this foreclosure, done by the same lawyer with the same witnesses at the same identical time, and filed 1 minute later on August 30th at 9:57.
Okay, may I inquire first as to both counsel? This is down for hearing on a motion for judgment of foreclosure, strict foreclosure, at 3:27. Now, I think I may know the answer to this, but I just want to be abundantly clear. Has a liability that is previously been determined in this case on that motion?
Yes, Your Honor. Liability was established as to different defendants at different times in this action. However, most operatively, Your Honor granted summary judgment as to liability on the defendant's answer back in February. One thing I want to make very clear, because brother...
Stop. I'm looking for that docket entry. Where is that?
Judge, this attorney's going to explode if you do not let him talk.
Can you,
Yeah,
correct me?
I wrote it down by date, not by docket number, so I'm looking for Your Honor granted summary judgment as to liability on February 21st, 2024 at pleading 314.05.
Hold on one moment.
You're drunk. They sound fine to me.
314.0, yeah, I see that. And then there was a attorney Brown, in light of that prior ruling on that date, you may certainly disagree, that's your prerogative. But liability has previously been determined. So much of what you are saying, I don't know that that would be square with what's before the court now.
Your Honor, if I may, just for the sake of the record, I would also point out that while Brother Counsel has represented today that there were unresolved special defenses, those special defenses were the subject of a motion to strike granted by Judge Gennario in November of 2018 at pleading 240.02. So when Your Honor acted on the motion for summary judgment, that was on the answer alone, as the special defenses were properly struck by agreement and never repled. There have not been special defenses, operative special defenses in this action for over 6 years.
Yeah, so there are no unresolved pleading issues, is what we're saying.
Yes, Your Honor. Completely agree with Your Honor.
Attorney Brown, certainly I'm going to hear you on what remains outstanding, and that is matters relevant to a sale or law day and finding the value in the debt and the like. But I don't know that we are. I think we're past the point, and again, subject to acknowledging your disagreement, we are past the point of really what you are saying here right now.
From my understanding of what we did back at the time of 240, that was on the counterclaim because of the Blowers case.
No, I disagree with you, sir.
2024. This happened just a couple days ago.
I spent some time with this file, as have many other judges here. It's been vigorously litigated, but I really think what we need to begin to focus on today is the motion for judgment of strict at 3
Please, the court, I'll briefly address our position. Not conceding, but assuming that Attorney Pocklington is correct on that.
He is.
My counterpoint would be that the court always sits as a court of equity. As a court of equity, they have to prove their title. As a court of law, they have to prove their title. They haven't proven their title. They can't.
I don't have a preference. If I have lovely toast, then I like over medium. If not, scrambled is fine. If you're just really lazy, Overheard is fine too. I don't. My least favorite is just sunny side up, where the other side is not cooked at all. That's my least favorite.
But it's been determined judicially. I mean, you may disagree with me, but it's been determined judicially, and I understand what you're doing and saying. But you are now asking the court on the which is on the precipice of ruling on the motion for judgment itself as to foreclosure, that you are asking the court, okay, our legal defenses did not sway the court, but Judge, we're asking you to take up this as a matter of equity. Right?
That's a fair statement, Your Honor, and I am, and I repeat that request to the court because equitable.
There is Katie's website, guys. Check it out. Hold on, we get to hear him talk. I want to go here.
That matters as well. Do you want to be heard here, sir?
The only thing that I'm going to do is I'm going to back what my lawyer said. This has been a travesty in this courthouse that they're doing a foreclosure when the deeds were invalidated in a trial in this room next door, and it went 20 years. I am going to file an appeal to the higher court. That's
certainly that is your prerogative. I respect that.
Thank you, Your Honor.
I do. Okay. Given everything said, I am going to set a law date of January 21. That's a Tuesday.
Oh, I'm going to get that,
and
guys.
Thereafter. All right?
Thank you.
January 21. Okay. Thank you all. I think that's the last matter, Madam Clerk. Am I right?
Donald, pretend when someone says egg, they mean steak. Just transfer the word in your head, and you'll be fine. CJ, we need more jokes. Drunken, you're right. You're right. Ah, look, guys. Yeah, he's like that with every case. I see a bunch of cases with him. I never show him here because you guys won't allow it. But what about bacon, Donald? Bacon and steak. Bacon and eggs. Don't tell Donald it's eggs. I didn't see today's, so I don't know if anything juicy happens. Let's start here. All right, let's start here. Hi, Judge. It's weird without chat. It's like I haven't really talked to the judge in a while. Oh boy, oh boy. I do want bacon and eggs so badly now, but I'm ordering bacon and eggs. Judge, will you talk to them for a minute so I can order some bacon and eggs? Oh, we get to hear Victoria too. Okay. We make this breakfast burger at lunch during brunch that is sinful. It's, a burger with an egg on it. But then we have this bacon jam that's on the bread. Oh my gosh, guys, it is so freaking delicious.
I don't know, but we haven't checked. His parents going to his aunt and uncle's house, or the family's going for Christmas. Come up, Mr. Poole.
Before we start, does anybody know what time the surgery is? What time in Judge Fleischer's time? Because that's where she lives. That's where Kelly lives. What time is she going into surgery? I miss Kelly so much. I don't like this.
Yes, sir. Tell me what's going on with your life
Hi, am
now. What are you doing with yourself?
I'm just trying to work on myself. I'm staying at the house, so
Okay.
I'm just like working out and doing whatever, trying to get all my schoolwork done. So I'm doing all my.
Are you in high school or are you in college? Where?
I'm a senior in high school.
You're a senior in high school.
I'm doing all my school right now.
Okay. How's that going?
It's going well.
Okay.
I'm about in my first semester.
You're what?
I'm about in my first semester.
Okay.
14th.
Are you seeing anyone? Counseling wise, are you seeing anyone? How does that work out?
It's online, but I was planning on doing it in person next week.
We'd like to get it online because, or excuse me, to in person, because as you can imagine, trying to do it
I
online.
need proof first, right? That he's
Proof of what?
that he's gonna go actually see someone, like he has an appointment, so we know he's not just gonna go visit friends.
How do you want to?
I don't know, maybe get a letter from the doctor showing that you have an appointment, that you're gonna go see him. What else are you requesting?
I just wanted to be able to go do the counseling that he's attending in person because it's per the counselor, and based on my experience doing the 20 years, it's significantly more helpful if you can actually do it in person instead of trying to do it through.
How often do you see this person? That's it? Okay. Do you want to do this on a weekly basis, or is this just a one-time deal now?
I think we should just do it whenever the counselor thinks that, whatever the counselor is prescribing is the best course of action.
Okay. Of course, I'm okay with it. I just want proof.
Okay.
I don't take anybody's word for anything. As much as I, admire and respect you, I don't trust anyone, right? Not you specifically, but
Understood. We will get you documentation. Who do you want us to provide that to?
just, you can give it to Alicia. Yeah, she's here every day. So just, you can email it to her. That should be sufficient. And then we can come up with a plan, but you go to the counselor and then you come back home. We have a monitor on you now, right? You need to understand, we know where you are at all times. So if you deviate, if you go to Speedy's Fast Track, or if you go to McDonald's, or if you do, we're going to know, and it's not going to end well for you. You understand? Okay. As far as Christmas, you said something else though.
Yeah, and so he's staying at home with his parents. The family all gets together in, one house. We'd like him to be able to go to that family Christmas event.
Okay. Is that one day?
For the one day for Christmas, to use like Christmas Eve, Christmas,
just one day.
Just
Okay. I'm okay with that.
Okay.
Remember, no using anything. If you are no contact with any of the alleged complaining witnesses.
Okay.
And I'm going to tell you now, if you get together with family members and the family members that you don't get along with, and there's the potential that you end up in an argument or a fight or something, it's not worth it. You need to consider that wherever you're going. All right. Okay. I'm with you.
Thank you, Judge.
All right.
Appreciate
Of
it.
course. Hi, Max.
It was the one that was last week.
Sure.
With the federal custody. She's here in the back.
Okay.
So I had her federal counsel provide me kind of a chart that explains the ranges and how the DWI will affect the ranges. And so currently with what she's pleading to, without the DWI, it puts her at roughly 2 years in federal custody. And that's the understanding is that's what the plan would be. With the DWI, it jumps it up to approximately 3 years. So it's actually, it adds about a year. My understanding is she's going to be pleading in early January, then is supposed to be scheduled to return approximately 3 months later for sentencing.
That's just too long, Max. I mean, it's just too long. I can't, that would be me giving her special favors when, the case now is, it's 230 days old. So you're waiting, you really want me to extend it to around what, 400 days? Or 350 days?
It would be in March, sometime in March.
No. Sentencing is.
Okay, I just ordered not eggs. I just ordered bacon, sausage, home fries, toast, and regs.
Way down the road.
No, so it's between, so the plea is in January and then sentencing will be in March and then she will go in later down the road. But we can do it before she goes in. So it would just be after she's sentenced in March, anytime after that. So theoretically, I've been trying to brainstorm. Theoretically, if we were to set it for trial, at least that could give us a backstop. And if she's not done, then, you know what I mean? No one's trying to like take
I
advantage of
understand you're trying to do what's best for your client, but I can't curry favor, right? I have to be fair to everyone. And me allowing her to extend the plea for her benefit is me currying favor for her.
Okay.
It is.
I understand.
So, I mean, I'm willing to go to January after she pleads in January, but after that, she's got to plead or we set up for
I think the
trial.
problem even with that is that pleading in January is happening, all right? That's like without a doubt. But I think if this is already there, if she pleads to this even after January, but before the sentencing, the
It's still
sentencing
gonna-
then hops up, right? I get it. I've got to try.
I know.
I guess, so problem for us is that she then cannot plead and like.
If you want to set it for trial now, we'll set it for trial. I can set it. Well, the trial dates are in, early February.
Okay.
Yeah.
I mean, I guess for now I'll have to, I guess I have to do that. If somehow I can get that amended, then changed, I will. I mean, she had no desire to go to trial, right? It's just this thing. Does that make sense?
Set it for trial, not reset. Maybe get mid-February.
Set it for trial.
Say it
We
again?
want to see judge in
I'm
trial.
just-
We love to see judge in trial. We saw 2 so far. I was gonna get Scrapple just for you guys, and I just felt bad that I didn't get Scrapple. Instead, I got sausage and bacon. I should have got Scrapple.
Come up.
Mr. Bledsoe. So I spoke with pretrial judge, and I spoke with the coordinator. Per pretrial, he's tested positive presumptively because they have to send it.
The Neptune Diner. Me and the Neptune Diner go way, 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 way back. I think it's been in this town longer than I have, which is saying something because I'm very, very old.
Allowed for confirmatory for alcohol and THC. I think they described his behavior as
Threatening.
Well, I didn't get threatening, but
I got threatening. And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond, and you now goes with you.
if I can judge, I don't believe there has been actually any evidence presented to warrant a
Hold
bond
on, Stephen.
revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge.
Don't
There was
speak.
no like threat of like harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, you know, putting anyone in danger, threatening danger, anything of that sort.
This is
all
what I
good
have
here.
an
We're all good.
open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand? Take a seat.
Thank you, Judge. Back to the point. Do you have a preference on the reset date, Judge?
Scrapple is like sausage. It's pork. It's like pork parts. And it's like a square. Think of the insides of a sausage, but only like in a square on your plate instead. And you fry it, and then you put like syrup on it. You don't have to put syrup on it, but it's delicious both ways.
So what? Tell me what he tested positive for.
It was THC and alcohol, Judge.
This is where I'll add that the court added bond conditions yesterday, so he had the magistrate.
understand.
Okay.
We did have these magistrate orders in October.
Yeah, but like sausage. It's more like sausage. It's delicious. Yeah, pork parts, just like sausage is pork parts.
And I did see that he was instructed over. It didn't have no alcohol, but it did have.
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe. BLED.
It really is delicious.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything.
If you ate sausage without the casing, would you say that tastes like Spam? Sausage? I don't think it tastes like Spam. Spam is more like ham, which is pig too, but
Being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I'll also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be.
sort of, yeah.
You will stay with me. Do you understand?
Yes, sir.
Get whatever records you need, but if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said
And
2
I'll
weeks.
test them back and we'll see.
Do you
But
want,
by then it'll be sufficient benefit that there's just no argument.
do you want him 2 weeks from today testing on that date?
Yeah.
Okay, we'll do. Thank you, Judge.
For sure, Nick. And thank you for coming back. I appreciate it. All right, Al. Hey,
I'm approaching on behalf of Tony Miles. He's currently
I thought he was back and he was just walking by. Don't walk by like that, sir. You're gonna get yelled at. Hi, Ramona. You look gorgeous today.
hi, Casey.
Hey, how you doing?
Good.
I do have a plea for you today on Mr. Bryant.
You say Mr. Bryant?
Yes, Jason Bryant.
Okay. Good morning, Mr. Bryant. Oh,
So it is actually not a second.
Your Honor, if I may, it's not a second because our investigator reached out to the county and found that the records were expunged. So,
it's still,
Your Honor, under the code, you can't use expunged records for purpose of enhancement. And we reached out to appellate to confirm that as well as other people, as well as from the AG's office, and they've all.
so what happened? Did it get dismissed?
So
Expunged?
it's a conviction that was
You still
expunged.
enhance it to a second?
We can't use
Not
the
within an
expunged records,
instruction.
Your Honor.
Technically, they shouldn't even know about it.
Yes, that's the issue. So for that reason is why we put a reduction to a first.
So if
Yes.
we could refile it as a.
Speaking of Judge Fleischer, have you guys all sent him a birthday card yet? Charlotte, you have. if anybody is international and does not want to spend so much money to send a birthday card the whole way to America, I have birthday cards ready. Tell me, and I will mail him a birthday card from you. I have 5 in my hand right here, but you know what? There's a store right down the street. They sell these things, a whole bunch of them. So, send him a birthday card. It only takes a second. If you need his address, it's in Discord. If you have any questions, ask Donald. Yep. He didn't acknowledge mine that I know of. And mine went out way ago. But, yep, send him a Hanukkah card. But he's turning 50. That's a big deal. Send him a birthday card. Please send him a birthday card. Please send him a birthday card.
First, but we're not allowed, like for our appellate division, we can't use it for any cases, like to upcharge to a second.
Here's the thing. You've already had one that's dismissed. You now pick up another one, right? You know, when do we say when? When do the proverbial slaps on the wrist stop? You know, how old are you now?
41.
You're 41. When do we get it? You know, do you watch the news? How many times a day do people die in Harris County because of the DWI?
Every day, all the time.
Every freaking day, every single day. And the problem here is that what I have found when we go too low on punishment with repeat offenders, I have found that they wrap their car around the pole the next week. And that's why I have an extremely hard time of taking another proverbial slap on the wrist if you've even had one dismissed. Because who's to say you've learned anything? Tell me about the facts, will you, please?
Yes, Judge. One moment, Judge. So the facts were the officers were dispatched to a major crash call, and a witness stated he arrived at the accident, observed the defendant sitting in the driver's seat of the vehicle with the engine still on, and saw the defendant get out of the vehicle and sit by a tree. The officers observed the defendant to be sitting under the tree near the vehicle and was.
Did you say there was an accident?
It was a single car
It was a single
accident,
accident.
Judge.
He had hit a tree, and then he was being treated by HFD upon the arrival of the officers. And the defendant's vehicle had right bumper damage and windshield down and the glove box open from the accident. And that's when the officers found a
2 guns.
yes, a loaded handgun on the sidewalk and another single 9mm near the vehicle. And then the officers then observed bloodshot, watery eyes, slurred speech, and a strong odor of alcohol coming from the defendant. And the defendant was unable to walk due to the injuries from the accident. So the defendant admitted to driving, crashing the vehicle, and owning the firearm. He also admitted to consuming the alcohol. And that's when the defendant was transported to Memorial Hermann by ambulance and was unable to perform SFSTs due to the hospital visit. And a blood draw was performed.
What was the blood?
It came back at 0.153.
Did you guys enhance it to a 15 above?
No, Your Honor, we did not.
How did they even charge it as a second when you're telling me that it's been expunged?
Originally, it was charged using the expunged records because they only ran an NCIC, and for some reason it came up on NCIC when it shouldn't have. That's the issue.
Forever, for the rest of your life, you now see, even if it's expunged, people still see it. Doesn't matter, you know? In the future, going forward, what do you think is going to happen if you get pulled over and an officer looks at your record? Right. From now on, you're looking at a minimum of 30 days in jail. I'm going to tell you now, Mr. Bright, I don't want to take this. I don't think it's fair. You know, I don't on any seconds because, you know, there has to be consequence for behavior and it's not fair. This is the last time you will get a proverbial slap on the wrist. I want you to understand that. Anytime you get pulled over, they're going to see all this. You will get taken down. All you have to do is push a button on your freaking phone. $30 to $40 on an Uber will take you anywhere you need to go. Do you understand? How much money have you paid them to represent you? How much money have you paid to represent on the first freaking DWI? And now you're back. I'm going to tell you, if you act like a child, I'm going to treat you like a child, and I'm going to put you over on my knee, and I'm going to spank you like a little child. You come back here, but I'm going to do it with a ton of jail time. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Do you understand? How to plead to the offense of driving while intoxicated. I will find you guilty. I will send you to 3 days in jail. I'll give you credit for 1. I'm going to suspend your license for a year. Do not drive until you get a license. I am also now going to hit you with the DPS surcharge that you will be required to pay. That is a $3,000 surcharge you're going to be required to pay. You will also be required to pay the court costs, which are around $400 to $500. And I'm going to tell you, we're going to get it one way or the other, because if you don't, every $100 that you owe, you will be sitting 1 day in jail. So you can imagine on a $35,000 to $4,000 bill right now that you're going to get, how much you will sit in jail. I want you to understand that we will not tolerate DWIs in Harris County, and we're going to get blood one way or the other. You understand?
Yes, sir.
It's just not fair when it's so easy to find another way. You know, I like to drink. I like to drink a lot. I love my mules, really, really spicy. And I love to go out with my wife. How do you think I do it though? Right. And then I can just be towed, you know, but that's the responsible thing to do. And I hope that you really get it from now on, because God forbid you do something that you really can't walk away from. Do you understand? All right. Good luck. Thank you.
Yes. Thank you.
If you're gonna give them 2 years?
Yeah, sure, of course. Okay, hi, Hugh.
Kendrick Boyd, docket, and he is in custody. See if we can get a trial setting for him.
Of course.
If we could do.
Hi, Ms. Brown. How are you? I'm sorry to see you in this circumstance. You know, you now picked up a terroristic threat, serious bodily injury. You're facing a year in jail. You know, the thing that I told all them that
he's the one we call Ryan Reynolds. But anyway, there's more to Will.
I'm happy that you didn't follow through. That, you know, sticks and stones, right? But words can hurt sometimes, right? As you now see, you've now picked up a new case. I don't know how we go forward now. What do we do? I don't know either. You're 19, right?
Will is a public defender.
Where do we go? Because you had a home to go to, but we don't know if we can put you back in the home. No way under any circumstance am I going to let you just out on the street. That's a death sentence. Because where would you go? Who are you going to be with? How are you going to eat? I can't do that. We can't just give you a PR bond. I have to know where you're going to go, who you're going to be with, so we don't set you up for failure. Do you know the phone number to that house? Have you given it to Josh? Okay, don't say it out loud. If you can write it down, we're going to try to get in contact with them. We can call now so that we can see if they're willing to take you back. And then we'll go from there, because I don't know how we're going to go forward. I don't want to let you out on the street. Is there anyone here, do you know, for her? You've been in contact with the caseworker, social worker, or no?
The caseworker and then also her appointed guardian.
Have you talked to them lately?
Not since this new case.
Okay, so I guess, can we try to do that today? Let's roll it to tomorrow. Let's see, are they gonna accept her back? If not, how do we go forward? I don't want to keep you here for a long time, but I don't know how to go forward at this time. So let's give it a day. Let's see what Josh can find and then we'll bring you back, okay? All right, sticks and stones, I'm glad that you didn't follow through. That's good. Now, we have to get you to learn self-control so that you don't flip out. That's the name of the game now, all right? Think about it. Okay, all right, thanks.
Paycheck.
Antonio.
Antonio.
Good morning, Your Honor. This is a new appointment, Sandra Dawn Stump.
One, and then they just have to do it over
a
again.
lawyer
I've
or
seen
is
it time and again, so I would just wait. Hey, you ready?
Yeah.
We're just waiting on someone. Talk to me.
Oh, she's a lawyer. She's not.
Yes, Your Honor, I am approaching a Mr. Jesse Johnson. So we're at 183 today.
Yeah, it's time. Do you have an offer on the case?
All right, this is the last
Yes,
one.
so I
and
have
then
been going back and forth with.
this is the last one, and then I'm gonna go to OJ. I should press play. That's better. Nice. Junebug. That was nice. Well
How old are you,
done.
man? Okay. No more alcohol. No more illegal drugs. Now, you only tested positive for alcohol. Good. But I don't want it for the foreseeable future for now. All right. Have you guys got the rip done? I saw Conrad here. He took off.
Your Honor, the RIP has not been completed on this one.
Conrad's in trial today, Judge, so I
Okay.
mean, we can ask him,
Just
but.
don't rush. I mean, if he's in trial, he's in trial. Let's not bother him, really. So Ms. Laverne, I don't want you to have contact with this person. I don't want you to have any weapons. You got out of jail because we gave you a PR bond. You're not gonna get another one. You gotta understand, you pick up a new case, you violate conditions, your bond hits $5,000 to $10,000. If you don't have anyone to pony up that money, you'll be stuck like Chuck. So just understand that. We're not asking for much. Be nice. It's not hard. You understand? No contact with this person. I've given you a lawyer. It's your responsibility to stay in touch with Josh. If Josh tells me he can't get a hold of you, ixnay on the PR bond A. Do you understand what that means? No more PR bond. Be nice. It's not hard. All right? Okay, man. We'll just have you sign a reset. And we'll have you get with Felicia if your bond finishes, and then you're free to go. Okay. Thanks, Josh.
All right, guys. Thank you so much for coming out today. I'm going to do the OJ trial next. Maybe, since it's only 6:18. I have time to do two if I get going right now and don't take my 3-minute break. And I don't have to cook anything because I ordered food and it should be here in, like, I don't know, soon. So I'm going to start a new stream real quick with sound. I'm going to have the right. Look, we're going to look at this together. This is where we're at. We're at 10. We're going to start 10. We're going to be 5. And I'm not even going to do an intro or outro. I'm just going to start the stream in like 1 minute to get it set up and then start OJ. Thank you so much for coming out, guys. I really appreciate it. Go buy some Scrapple. Try it. Put some syrup on it. Put some maple syrup on it. And I'll see you guys soon. Thank you so much. Thank you.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night when the world sleeps, she's the friend that always keeps. feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no